I'm going to call the meeting of the Criminal Justice Courting Council to order. I want to welcome everyone to the meeting for August 11th, 2020. The first item on our agenda is open comment from Judge Mccabria. Is Judge Mccabria on the call?
See, I don't see him in the room yet, Pam.
Well, I think maybe we should move on to the next agenda and have him talk near the end. You want to wait or?
I say move on.
Okay. Well, earlier this summer, I reached out to the Kansas State Board of Indigent Defense Services, and their director, Heather Cessna, is on with us this morning to talk to us about what it would mean to have a public defender's office in Douglas County, or what it would take to have a public defender's office. And so she's going to provide you with a PowerPoint this morning and be open to your questions. Heather, can you go ahead and start?
Yes, well, thank you, first of all, for letting me come and talk to the group. I'm going to give just a little brief overview of sort of how we handle appointment systems and talk a little bit about sort of the process for where the board will, step in to potentially put a public defender in various areas and how that process works. So I'll go ahead and start, and you have to forgive me because this is literally the first time I've actually attempted to screen share. So, so hopefully this will work. All right, let's go back. So as Pam said, she reached out to me earlier this summer to talk about the question of a public defender system as part of the Douglas County Indigent Defense Services. And I am the executive director of the Board of Indigent Defense Services in Topeka. And so I was going to start by telling you a little bit more about the board, because honestly, we're kind of one of those boards that flies under the radar a lot, and people know us by our acronym BIDS, but then don't really know what we do. So for those of you who are not familiar with our agency, I thought I'd start off just a little bit with that. First of all, out of all of the criminal cases in Kansas, about 85% of adult felony criminal defendants require appointed counsel. And out of those 85% of adult felony criminal defendants, we handle the appointments for all of those. We do that through two different systems, both a statewide network of public defender offices and also through appointed private counsel appointments lists and contracts that are basically private attorneys who are then paid by bids. And we do provide other support services for those attorneys too, such as providing expert services and things of that nature. So the assigned counsel program is definitely something that your county is probably most familiar with because your county does utilize a full appointments list and does not have a specific contract counsel that handles appointments right off the bat and doesn't have a public defender office. That appointments list is always made up of private attorneys who volunteer to be on the list. There are some minimum requirements that we have in order to make sure that the people who are being assigned to represent defendants on particular cases are qualified to do so. I mean, you're not going to qualify to represent a person who's been accused of premeditated first-degree murder if you're fresh out of law school and have never done a criminal case before. So there are some minimum requirements, but for the most part, the assigned counsel program is a very independent entity. We don't have a lot of control over pretty much anything other than some of the expert payments that we make. If they if a attorney decides they need an expert, we do have a little bit of control over some of those issues to try to control costs. But pretty much at the end of the day, we get the bill after the program has been, billed for the attorney services, and that's not all there is to it. Now, our public defender offices, we do have a statewide network of those offices. There are 18 public defender offices, including our administrative office throughout the state of Kansas. Out of those 18 offices, 11 of them are trial public defender offices. We have 2 offices in Topeka and Wichita. Both of those cities have a public defender and a conflicts public defender because of their caseload sizes. And then we have 1 public defender's office in Olathe, 1 in Junction, 1 in Salina, 1 in Hutchinson, 1 in Chanute, and 1 in Independence, and then another 1 in Garden City. So we're kind of spread out all over the place. And those public defender's offices act as like the first appointments in those areas. And we still have private counsel who acts as appointed attorneys on an appointments list, even where we have public defender's offices, because of conflicts issues and because, you know, you're always going to have defendants who run through multiple attorneys during the process. And then also because we do have institutional caseload controls that we try to keep a good handle on, sometimes more effectively than others. And so there's a lot of times where we will have to stop a public defender's office from taking appointments in order to control our caseloads. And at that point, cases pretty much go directly to the appointments lists in those areas. So even where we have public defender's offices, we almost always have backup contract counsel, or we, you know, extensively utilize the appointment system even in those areas. So the board is given the direct authority to determine what kind of a system to use where, and that's under KSA 224522. And we can use pretty much any combination depending on the analysis of the board and what they feel like is going to work best in a given area. However, before we do any changes to the way that we give out legal services in any particular jurisdiction, we do have to hold public hearings. There has to be at least 2 board members who are interested in considering such a change. So there's a process there that we have to go through before we consider changing from one system to another. As I said, Douglas County is probably most familiar with, because that's what you guys have, a private appointments list. And so I wanted to talk a little bit about that. I provided some information, and I'm sure Pam's probably given that to all of you. But here's some of the breakdown of the number of cases that we've received appointed attorney vouchers on over the last 5-6 years, and the total cost of those, and then the cost per case. You'll notice that the FY 2020 numbers are a little bit lower than 2019. That is primarily because pretty much the entire last quarter of our fiscal year from April through June was subject to court shutdowns, and as a result of that, we don't get vouchers until after cases are finished, and so a lot of cases basically got put on hold and weren't finished. We did offer some interim billing for some attorneys who wanted to take advantage of that, but by and large, a lot of them were just waiting until their cases can be moved along. So I would say that if you're looking at sort of the trends, I think probably that 2020 number is going to be a outlier. So I kind of focused on looking at the fiscal year 2019 as probably more typically representative of what the number of cases that we would see in the total cost. So for those of you who may be listening in on the phone and not watching the video, the number of cases in fiscal year 2019 in Douglas County from appointed counsel vouchers was 736 cases for a total cost of $828,762. And that roughly equals out to about $1,126 per case that cost the board to pay for those attorneys. When I was asked by Pam to kind of look at the potential costs of a public defender's office in Douglas County, I looked at that fiscal year 2019 number because, like I said, I think that was probably more comparable for what our typical caseload would be. And I looked at the number of cases that we have in Douglas County, that like 736 cases that we typically see, and looked at sort of a comparably sized caseload for our other public defender's offices. We have a public defender's office in Hutchinson that handles a caseload that's relatively comparable to that. And so I looked at their operational costs and the costs of their attorneys. They have 5 attorneys in that office. They really should have 6. And 3 staff members, 4 staff members occasionally there. And so looking at sort of their operational costs and then kind of guesstimating some things that are a little bit different between Hutchinson and Lawrence, as far as things like rent and stuff like that, we kind of came up with a very, very rough estimate that a public defender's office of a similar size in Lawrence would probably be around $810,000 a year in order to operate. And so the cost comparison is relatively equivalent. And as I said, that was a very rough estimate. I mean, it would obviously change substantially depending on actual availability of space and the actual rents that might be charged for a public defender's office of that size and things of that nature. And of course, depending on when we would look at actually implementing something like that, the cost for salaries and things like that can go up too. So, but judging based on, as I said, a comparable sized office, that was about what we kind of came up with. So, you know, it's kind of a relatively equal comparison on that rough estimate. The thing that the board would consider, and I'm the executive director, so obviously, I mean, I can talk to the board about these kinds of things, but they certainly have a mind of their own. We have 9 board positions, 8 of which are currently filled, and the board consists of right now 3 public members who are involved in various aspects of criminal justice issues, and then a number of attorneys who 2 of whom are former public defenders and several of whom are private attorneys, one of whom has done appointments before. So, you know, we've got kind of a mix of people on the board for sure. And so they obviously would have a mind of their own. But as far as considerations that I would tell them to consider when looking at whether or not a public defense system should be considered for a particular area, I mean, we would look at the immediate relative costs of private attorneys versus the public defender, so that, you know, we would probably do a much more in-depth analysis of how much a public defender office would cost in a particular area versus how much we're paying in the private attorney vouchers. We're going to look down the line costs of both systems, things like ineffective assistance of counsel claims, wrongful convictions, etc. One of the issues with a voucher system or an appointment system versus a public defender system is that when we have a network of private attorneys who are handling cases, we don't have any kind of quality controls over those attorneys' performances until much later on in the system, if like a client tries to file an ineffective assistance of counsel claim or a malpractice claim or a wrongful conviction claim. Whereas a public defender system, we have much more immediate supervision over the day-to-day operations and the quality of representation that we're presenting. So some of those down the line costs can, you know, potentially be avoided more quickly in a public defense system versus a private system. But that's not, you know, that's, you know, so that will be a consideration as well. Funding availability and sources. I know you all have probably been struggling in your individual areas with these issues, particularly as a result of the pandemic, and we're certainly no different. We've been asked to provide some reduced resources budget analysis as a result of the lack of state funds because of COVID. And even on a non-pandemic year, certainly state funding is always highly sought after and extremely competitive. So the funding availability and sources for establishing a new office is always going to be part of the analysis for any kind of a change like that. And of course, community interest and support. As you can imagine, traditionally in the past, I think when we've looked at these issues in Douglas County and in other areas, you know, there's been a variety of interests and support or non-support. And so, you know, having that input, getting a pulse on where the community is, you know, what the concerns are, what the, you know, what the thought process is always going to be an important consideration for the board. And also agency priorities. One of the things that I told Pam in my letter talking about this process is that one of the difficulties that we particularly have right now at the board is that we have a lot of caseload issues and turnover issues throughout our system. And so our priority right now is trying to stabilize those issues and get a better handle on our caseloads and trying to make sure that we're sufficiently staffed and sufficiently funded better than we have been in the past. And, you know, it's kind of that, it's that age old thing whenever you get on a plane and they tell you to put your, you know, put your oxygen mask on first before you help, you know, the person next to you. And, you know, so we definitely have some work to do in our own agency. And so to the extent that, you know, we need to consider whether or not we can support the resources we have versus then taking on new additions. That's going to play a role in some of the considerations for the board as well. Of course, the considerations for the community are going to be what benefits, you know, would the change bring to your local system and what the drawbacks are. Obviously, and this is kind of one of the things that I wanted to talk to the group a little bit about, because it's one of the things that unless you've particularly practiced in an area where there is a public defender, or unless you're particularly knowledgeable about the public defender system, you may not sort of know what some of the benefits are to having a public defender. And so one of the things that I wanted to point out is that having a public defender in your community is a certain amount of institutional support that otherwise does not exist. And that doesn't mean that it's necessarily better. You can certainly have some really good appointed attorneys that do a great job all the time. But it is going to be different in that you have, like I said earlier, you have a system that basically provides that direct supervision and immediate supervision of the attorneys who are operating in the criminal justice system, and a public defender in a way that you don't have with some of the private attorneys. You also have institutional caseload controls and management. As I said, that's one of the issues that we're working on in the agency in general, and certainly something we're trying to be better at. But there's also mechanisms for, as I said, shutting down if we have too many cases and letting more of those cases go directly to the panel attorneys and things like that. Whereas a lot of that has to be internally handled by private counsel when you have an appointed attorney, and so you're essentially relying on that appointed attorney to have good decision making about whether or not they should continue taking on cases. And as I said, a lot of attorneys are really good about that. I mean, certainly taking on too many cases becomes potentially an ethics issue. So they have definitely good motivation for keeping track of that themselves, but you know, you don't have that kind of oversight the way that you do with public defender system. So that would be a difference between the two. You also have sort of the weight of the system behind you, in that you have, you know, resources that the individual private attorneys would not have. I mean, one of the benefits to a public defender in any area is that you have not only that group of attorneys that's standing there, but you also have all of the other public defenders in the entire system. That means, you know, they regularly go to the appellate defender office for for resources and help. You know, we utilize our capital attorneys to provide, you know, some consultations and assistance, even in some non-capital cases if it's applicable. Certainly there are a lot of longtime defenders across the agency who provide, you know, consultation if requested. And we also are organizational members of groups like the National Association for Public Defense that in and of itself provides a lot of institutional support and benefits to the agency in a way that private attorneys on an appointments list just don't have the same kind of access to. And so, you know, that is also a change that comes to the community. And one of the things to consider is that, you know, certainly the private counsel in any area are going to have the opportunity to come to bids and ask for some of that assistance, and a lot of them do. In fact, prior to becoming the executive director of the agency, I was a longtime appellate defender, and I regularly fielded phone calls from private counsel who were appointed to cases on questions that they were concerned about in their trial cases. And in fact, many of them were actually from Douglas County. And so it's, you know, it's not that those things are not readily available, but it's dependent on that individual attorney to reach out and seek it out in a way that is, you know, sort of just automatically provided for the public defenders as part of that system. So again, you know, without necessarily commenting on whether one side is better than the other or anything like that, it's just a difference in how it manifests itself on the ground in the courtroom. And, you know, anytime you have additional resources in a community, I mean, it's sort of that idea of a rising tide raises all boats. You know, by having those additional resources there, it provides the opportunity for all counsel, whether it's the public defenders or whether it's private counsel or potentially contract counsel who may be involved in cases, to develop those local connections and have more opportunities to take, you know, benefits from what our public defender side of our system can offer. So, you know, it's one of those things where it's a different way of delivering a more organized and probably more easily accessible set of benefits that otherwise would be somewhat difficult, I think, for individual attorneys to take advantage of. And like I said, a lot of individual attorneys do take advantage of that, but you know, some don't, and it's really dependent on the individual attorneys who are involved in your panel. So if you have a particularly good panel, then that may not be a particular concern to you. If you've, you know, got a large panel that has a lot of brand new attorneys that maybe don't even know what some of the benefits are, then that takes a little more education in order to make sure that they know what resources are out there for them. So it really depends on sort of what your individual circumstances have. So let's talk a little bit about the process. If people in Douglas County are interested in potentially bringing in a public defender, the first step would be basically to make a formal request to the board. And that can be something as simple as coming to a board meeting and addressing the board. It can be an official letter to ask the board to consider the request. You know, anything really can qualify. At that point, you know, once the board is approached with interest, then a couple things are going to happen. At least 2 board members will have to vote to hold a hearing prior to making any changes. That's based on that statutory rule that we talked about earlier. We in the bids administration would have to work up sort of a cost benefit analysis for the board. That would be a much more specific analysis than what I provided for this purpose today. But it would definitely involve quite a bit of analysis about the costs of the cases and some of those specific considerations, like literally like space issues and things like that. So The board would then hold a public hearing. I think in the past we've held multiple public hearings depending on the interest in the community, in order to make sure that, you know, we were available to answer questions or to hear public comment on the issue. And then at that point, the board would have to consider the actual question at a board meeting as to whether or not to pursue a change in the legal system and have a public vote on that. And of course, at that point, even if there was a public vote, any kind of a decision would very much be dependent upon securing sufficient funding to support that change. And the way that we secure that funding is to go to the governor and the legislature and to ask for it. So as you can imagine, that process is a relatively lengthy and somewhat, you know, somewhat of a roller coaster, even in the best of fiscal years. So any kind of a change would have to be supported by sufficient funding in order to do that. As I said, I kind of wanted to summarize before I kind of open it up to any questions that you all might have. You know, any proposed change in any kind of a system in anywhere, whether it's Douglas County or any other county, is going to take some time to implement. It's not an immediate solution. It's not an immediate change. Our budget process is such that within the next month, we're submitting a budget for our fiscal year 2022. And so, you know, because of a process, even if we were asked today to look into the question of a public defender in Douglas County, we wouldn't even be able to get through that process and make a request to the legislature for funding until this time next year. And then it would be, you know, we'd have to go through the entire legislative session in 2022 before we would know if we got the funding for it. So it's definitely a long process. Any proposed change, as I said, is going to have to be sufficiently funded, because the fact of the matter is if we can't support it, then we can't physically do it. And even where we have multiple public defenders offices, the county is still going to maintain a robust local appointments list. So that's, you know, even if you changed over and added a public defender, you're not going to lose an appointments list. You're still going to have an appointments list, and that appointments list is going to regularly be used. And as I said, that's partially because of public defender caseload controls. That's partially because of conflicts issues, and, you know, clients who go through multiple attorneys on a case. So, you know, it's not an either or scenario. It's usually having an appointments list on its own or having both a public defender and an appointments list. So, you know, that kind of gives you a little bit of an overview of some of the considerations and a little bit of details on some of the costs. But certainly I am definitely open for questions if anybody has anything they want to ask.
Heather, thanks so much. This was really, really helpful overview. I have a few questions, but I want to give everybody else an opportunity to ask theirs first.
Hopefully I wasn't talking too quickly.
Seeing that nobody's asked, I have a few questions for you. So the bids only covers felony cases, correct? It's not misdemeanors?
Right. It's only, right now we only do adult felonies. We have some leeway to accept occasional misdemeanors, but usually, I mean, for the most part, we haven't had the actual staffing to be able to handle that, and we don't do that statewide at all. Okay. We do some, in some counties, we provide like drug court support. I know like in Wichita, we actually provide a contract counsel for drug court. In Salina, our public defenders handle drug court. I think Riley County is looking at having our public defender in Junction City support drug court. So there's some of that stuff that we do too that's not just the straight up, you know, in the court adult felonies, but we do participate in some of those things too.
And then what about first appearance? Do you support first appearance counsel at all?
If we had a public defender's office that was sufficiently staffed, we can do that. Right now, the only public defender's office that regularly supports first appearances is the Johnson County office, and that's partially because of staffing issues in several of our other offices. But in Johnson County, they do support first appearances, and that's something that I personally would like to encourage the board to make sure that we've got the staffing to be able to do that everywhere.
That'd be great. My last question is about financial support. As you may know, the county supports a lot of state-funded programs. They have to help finance some additional costs for those programs. Do any of the counties supplement funding to the BIDS programs?
The places where we currently get supplemental funding is usually the drug court areas. We do get funding like in Salina from the county to support the time that we have our public defenders spend in drug court. Certainly, especially with the kind of issues that we've had with funding just over the course of time in general, I think we would be open to exploring the possibility of additional modes of funding, but that's not something that we've gotten into in great detail anywhere else yet.
Thank you. Does anybody else have any questions for Heather?
I do, actually. Hi, Heather. Thanks, that was actually super informative. So no, you were not talking very fast. For someone who doesn't know anything, that was actually really useful. We're in the middle here in CJCC of kind of looking at a variety of things. I'm sort of wondering if the board has done any sort of digging into how public defender offices that exist now affect equity across. You've already sort of talked about drug courts, but thinking about how particularly outcomes across a variety of demographics are affected by having a public defender office present in the jurisdiction. Has that been delved into at all? Is that something, and is that, if it has, is that data that's available?
That is not an area where we have collected a lot of data, and I will be the first to admit that that's an area that we should be doing more work on. One of the just as background information for this group, we're kind of in a transition period over the last year in our agency. Our previous director was with us for about 20 years. We had a lot of vacancies on our board that were not filled for a while. Over the last year, I've come on as the new executive director, and we've filled most of our vacancies. We only have one vacancy that's currently empty right now. And we've made an effort to fill those vacancies with people who are interested in trying to, to do better as far as what our agency is offering. And so that is one of the areas that we have not traditionally been very good about collecting information on, and it's something that we're going to work on doing better, but it's not something that we have readily available in a meaningful manner right now.
Thanks, Heather.
Yeah.
I guess I'm gonna a follow-up. This is maybe putting you unfairly on the spot then. As executive director, do you have, this is really unfair, do you have impressions about how, based in your experience, both having done appellate work and now in your position with the board, how that affects outcomes, like the presence of the public defender?
You mean the difference between a public defender versus like a private plaintiff?
Mm-hmm. Yes.
I mean, I do, and this is, like I said, I mean, this is definitely my impression, and so don't, hold me to it as far as I don't have the kind of data to support it that we probably should have, but I think the difference that we see a lot, I think, between the kind of representation on issues that affect racial equality in our criminal justice system is a lot of times going to be related to the ability of the system to challenge these issues. Challenging this in one case or with one particular situation is usually not going to result in any kind of systematic change. And so to the extent that you can utilize multiple attorneys across multiple cases to try to challenge whatever the particular concern is in a jurisdiction, you're much more likely to get a better result, because it takes a number of cases to come up through the system, and even if the district court denies relief on some of them, by the time they get to appeal, it takes a number of those cases to get through appeal before you get a panel on appeal that will decide a case the way that you may want it decided. And then oftentimes that requires it to even go up further to the Kansas Supreme Court. And so just by literally the numbers game. You're going to be able to make more effective change if you've got a more coordinated effort at challenging something. And it is definitely institutionally easier for a public defender to do that sort of coordinated effort on these issues than it would be to get a group of private attorneys. Now, that's not to say it's not possible to get a group of private attorneys to attempt to litigate an issue in a consistent manner. It just is going to be more difficult to get a group who is going to participate in that sort of a systematic approach. And so to that extent, having that institution there is going to benefit if you're trying to make some of those systematic changes. So that's my impression, though. And I will admit, I definitely come to this with my own personal bias, in the sense that because I was a public defender and I did see, some of those pushes in particular areas to try to get, challenge whatever local rule they felt like needed to be changed, or whatever issue was coming up. That's definitely something that I've seen happen in the past. And it's, been relatively effective if you've got more people participating in that.
Thank you.
Yes.
Do we have any other questions? Seeing none, thank you so much, Heather, for your time. This is really helpful for the board to hear what bids can
Actually,
offer
Pam,
to the county.
Pam, I do have a question, if I could.
Sure.
Thank you, Heather. This may be difficult to address, but I have a question about the politics of this in terms of the process. I think I understood you to say that in order to initiate the process, a request would have to come from the jurisdiction. Did I hear you correct on that? And if so, where does that typically come from? Is that the county commission in Douglas County?
I don't think it has to be anything quite that formal. Certainly, anybody can come to a board meeting and talk to the board about issues that they're interested in, and the board can consider whether or not it's something they want to address at that point. So if there is community interest that is particularly substantial, it might help to have a more formal request, but certainly it's not a requirement. I think if you do have community support that is more formalized and kind of consolidated together, then it's probably more likely that the board will seriously consider looking into that. But that's not to say that they wouldn't look into it, even if it's just somebody who was interested in asking the question. So, and certainly looking into it is not quite the same as actually deciding. So, that's my impression of our current board so far has been that they're very, very interested in talking about a lot of different things and kind of considering all their options. That doesn't necessarily mean that they would then decide to go one way or another just because they decided to look into it. So I don't think it has to be quite that formal. I think it just needs to be brought to the board. One of the impressions I had from Pam early on in our conversations was that this was sort of a handout, to ask for some information, that this was not necessarily a specific request. This process here was not specifically a request for the board to consider it. It was mostly for me to kind of provide some information to the community in case anyone was interested in this topic. And I've told the board that I was going to be having some of these conversations. And we have a board meeting this Friday, so we'll probably talk about that a little bit as well. But that's probably not, unless we are asked specifically to look into it, that's probably as far as it'll go at this point. I hope that answered your question.
And just, I'm sorry, I'm just bumping my gums. So in that case, if a body such as the CJCC said, "Hey, we actually are interested," that not being the Douglas County Commission would not stop the board from being able to pursue looking at or beginning the inquiry? Yes, or
I mean, I am sure that there's going to be probably a lot of opinions on both sides of the question. Anytime that we look into this in any county, not just in Douglas County. And so, you know, as I said, I don't know that that it would necessarily stop the board from looking into it. It would be up to the individual board members and how they ultimately voted as to whether or not it was something that we kind of explored. So.
This is Sarah, and I apologize. I was not able to hear all of your presentation due to a conflict, but yeah, and I guess I'm glad to hear that I was under the impression that more counties subsidized the public defender program than just Johnson.
Well, we do have a couple areas that do subsidize. Sedgwick County provides us money for contract counsel for a drug court. As I said, Saline County provides money directly to us for the public defenders to do drug court. So there is some of that. The vast majority of our funding though comes from state general funds.
Okay. And what about, like, I mean, you did talk about like availability of office space. What about just general contractual? I know I'm getting into the weeds with this kind of question, but I'm just trying to figure out if the relationship is similar to what the county has with the district court, which is where we provide a significant amount of funding for the base operations. We just don't pay for staff. Does it work similar to that?
In the areas where we do get funding from the county so far, and like I said, I would have to actually get into the weeds to see what kind of options there are for anything beyond this, just because I'm not that familiar with what our options are, because I'm relatively new to the position. But as far as what we've done in the past, we get direct payments, like for instance in Saline County. The county, I think through some kind of a grant program, receives money and then passes that to us so that we can use that as part of our funding, and we then use that to supplement the operations in that particular office that handles like their drug court representation. And so we track that funding through our system, but it's not paid necessarily to the attorneys directly from the county. Right.
But it would go to support the overall operation.
Right.
Yeah. So I think that's an important consideration too, is just as well as we think about, you know, how, if this is something that we want to explore as a county, what would those costs be, and what would be needed with them? And then, you know, my understanding too, and if you covered this, I apologize, was that some of it is based off of staffing levels, that the board would decide what they could provide in terms of staff. But if there was some concern that wasn't enough, that some courts still do either contract counsel in addition to that, or other, I guess that was my impression.
No, we use, when I say contract counsel, we, in some of our more populated areas that have larger caseloads, we have a public defender, like for instance in Topeka, we have a public defender's office in Topeka. We also have a conflicts public defender's office in Topeka that supports that office both by taking conflicts that the first public defender can't take, and then also provide some caseload overflow. We then have a contract counsel that is a backup counsel. It's a private firm in Topeka that we contract with to act as the backup to the two public defenders' offices. And then we have the full panel of appointed attorneys in Topeka that take cases. And I think if you know anybody who practices in Topeka, they can tell you that panel gets overwhelmed pretty quickly on a regular basis, because we have had some turnover in caseload issues with our public defenders' offices that then have caused our contract provider to also stop taking cases and that sort of thing. So it's not, the county doesn't pay for the contract. We pay for the contract provider, and we pay for the vouchers for the assigned counsel program too, for the appointments list. It's just sort of the mechanism that we've set up to provide a couple levels of support there.
Thank you.
Mm-hmm.
I think all the questions are done. Thank you so much, Heather. We'll reach out if we have additional questions. We'll be posting your presentation this afternoon on the CJCC website.
I appreciate it. Thank you very much. And if anyone has any questions, don't hesitate to reach out.
Thank you so much again. Judge Mccabria, I think we bounced you to the next item if you want to present your comments. You're on mute. Judge, you're on mute.
How about that? Probably hear me better.
Much better, thank you.
All right. Well, I apologize. I think this job comes with some sort of time warp because I looked at the clock at 10:30 and I looked 5 minutes later and it was 5 minutes after 11. So I don't know how that happens, but I apologize for being late and I appreciate you letting me jump in. I'll try to be quick. You know, I have been a part of CJCC since I became chief judge in Douglas County, and that was in January of this year. And so, frankly, I didn't pay a whole lot of attention to the details or particulars of how CJCC operated. I left that to our other chiefs who did a good job. But when I came on, I started with reading the bylaws, and because of the nature of what's happening and the nature of the bylaws sort of explains it. I mean, this is a group of a lot of people in the community who are working in a collaborative way, according to the bylaws, a working forum to support communication and collaborative coordination between and among key criminal justice system officials, advisory boards, agencies, departments, and community members to promote public health, public safety, and an effective, equitable, and efficient criminal justice system in our community. There's nothing about the judicial canons or ethics that prohibits. In fact, judges are encouraged to participate in such groups. And so my only thought process, as I've watched sometimes how CJCC activities are reported or presented to the county commission or to the city commission, when I hear things that tend towards an interpretation that lends itself to CJCC has certain goals or objectives, and therefore all the members of CJCC, and you can go to the bylaws and see who those members are, and the first listed member is the chief judge of the 7th Judicial District. The concern becomes, on my part, that there's a perception that that is also the position of the 7th Judicial District. And so I just wanted to take an opportunity, really for 2 reasons, to comment today, mostly to clarify the court's view of why and how it is participating in the CJCC. But I think as a corollary of that, my hope is that there would be a encouragement to all of the CJCC members to put their voice into the mix. And even if that includes, and frankly, mostly if it includes some dissent or some challenging of ideas, because to me, the full value and purpose of this council is going to be realized when we have, I mean, the composition of this council is fantastic. We have really all the players in the system, and we all have our roles, and we haven't had the opportunity outside of this forum to meet and to put all those ideas on the table for the purposes that are stated in the bylaws. But so, you know, judges and lawyers are used to working in an adversarial system. And I think a lot of people have a negative connotation of adversary, but really it's just the belief that competing ideas are put on the table and they're hashed out. And then the court, in its ultimate wisdom, as the neutral party in that scenario, has to decide the case. And I guess I find myself now in a situation where I still believe in the idea that competing ideas are going to be the best, produce the best outcome. But now the court is listed as a participant in the sharing of ideas. And I just worry that the perception is that by sharing views, we become, I don't want the community to question the independence of the judiciary or to think that we have lost our ability to be unbiased because we're participating in this process as well. And so I've talked to Sarah Plinsky about it. I've talked to Mike Brower about it. And they have been great in trying to help me keep my comfort level with that. Mike gets put on the hot seat and, is not a lawyer and so doesn't use lawyer speak. So I'm trying not to use lawyer speak today and just sharing with all of the council members the court's role. We have some ethical canons that govern the extent to which we can participate in what may be perceived, even if it's set up as a neutral organization, what may be perceived by the community as advocating for certain positions versus exploring ideas and the court contributing its experience and knowledge to those circumstances. I believe that the council has the opportunity to do great things. I want to continue to participate in the process. So my purpose here today is twofold. To the extent that the media may report any of these comments, I just want to assure Douglas County citizens that all of our judges take their job seriously, to be independent, to decide cases on their merits, and not to push forward any agenda other than what we think the law and the circumstances require, and to encourage all the members of the CJCC, including the courts, to be frank in sharing opinions and exploring the information that we're presented. I hear sometimes, goals stated as being a consensus among the members. I'm not aware that votes have been taken to substantiate those positions, and I'm not necessarily advocating that we do that, because I think once we start to take certain positions on certain issues, it's going to cause me some anxiety about whether the court can continue to participate. But so to the extent that CJCC certainly has value and we want to participate, we're glad to do that. To the extent that there's ever commentary or perceptions that CJCC has taken a position, that may occur, but it should not be interpreted as the official position of the district court. And even if one of the best things that I think has happened since we've been participating more actively, or at least my perception, since I'm involved more this year, a couple of the judges have been very good about helping to dig into some of the information that Dr. Cravens has been going through, and at least my perception is that it's been tremendously helpful. And that's the sense I get in speaking with him and with Mike, that analyzing and understanding just by the addition of that additional point of view and perspective produces a better product. And that's what I'm hoping our participation can do in all aspects of the issues that we look at. Even if it's not popular, I encourage other participants to, I don't know if you can hear the generator outside my office window just came on for our monthly 1-hour generator test. So I'll try to speak up. I sense that there's a lot of watching and listening and not maybe in this setting, it's hard to do, but I just encourage all the CJCC members to put forward their perspective, because I think that only helps the rest of us and helps the community have a better understanding of what the criminal justice system in Douglas County can do and how it can do it better. So I don't know if I said everything in a way that made sense, but I wanted to at least have the opportunity to address it in a public way and to say thank you for letting us participate.
Thank you, Judge. Did we have any follow-up comments to that?
Judge, I don't know what impact this has, but one of the things that your comments made me think of, as we're thinking about the multiple roles that we all play in our communities and in our lives, my day job as Title IX coordinator, every single time I've interviewed for that position, because I've done work for victims of sexual and domestic violence throughout my career for more than a decade, is how can you be neutral in these cases? And my response has always been, I will always be neutral about the facts. I will never be neutral about rape. And I think that, that you were speaking kind of to that distinction that we have to make, that we have to live into our roles and do our roles, and we are part of this bigger picture.
Oh, I think that's great, Jennifer. I agree, or Marinanda, I should say. Yes, there's that. And I don't want to have an overblown sense of self-importance, but there are canons of judicial conduct that, I've gone back and looked at a couple of different judicial ethics opinions on what sort of boards and organizations can judges participate in and what sort can't they. And even when they can, if it's a public perception issue, then there's just things that the court needs to be mindful of. And, I thought about defense attorneys as I was listening to Heather Cessna's presentation. I mean, the public perception of defense attorneys is along the lines of what you said. How can you possibly represent these people that did wrong things? But that's their job, and that doesn't mean that they agree with doing bad things. They have a job to do, and ethically they're required to do it. The judges and people who are familiar with the system don't have that same bias or prejudice to a large degree against defense attorneys, or maybe the public perceptions now is maybe turned a little bit towards prosecutors. But when you're in the system, you have a perspective and understanding that the public may not have, and that's the same sort of concern I have here, that the public perceives the council as something that it is not, and that is not in any way intended to take away from the importance of what the council can do. Just in the same way, it's important what the court does despite the public perceptions that sometimes attach. So I'm just being guarded and territorial about the independence of the judiciary, and I don't want the public perception to be lost by virtue of the fact that we want to participate in this process. So
can I ask a question or open up something? And thank you, Judge, for that. And I think a lot of this opens up some questions that I have because I am even newer than you here. And I guess I kind of want to go back to this point of dissent that you brought up. I think I'm trying to wrap my mind around what you're wanting from us as actual members, because I still am trying to get into my mind exactly what the powers of CJCC or the expectations or responsibility are. And am I hearing you in saying that to protect or to ensure that the public understands that the judiciary is not, that the CJCC is not a rubber stamp for the judiciary or the reverse?
Right.
You're asking for us to speak up more, to lean into dissent, to talk more openly in the public about discussions within the CJCC. And maybe this isn't just a question for Judge Mccabria, but I will say that I'm trying to kind of get my mind around what actionably that might mean for us.
Yeah, no, it's a great question. And I, as I was speaking, I thought I'm not doing a good job of explaining my secondary purpose. So the dissent that I'm encouraging is among the members of the CJCC themselves. That is, it's a very tough role to be in, to be on a board that is looking at something that affects the lives of so many people in such profound ways. And there is the distinction that I would make is there's the reality of how the criminal justice system happens and the people who are in it every day. That is, let me make it narrower, in the courtrooms every day. And that goes back to the example I was trying to use when Marinanda mentioned, you know, I think it's very fair to say there's a public perception of, a longstanding public perception of defense attorneys that a lot of people hold. There's certain perceptions in modern times that have been more vocal about the perceptions of what prosecutors do and of what judges do. But when you're in the system every day, I believe that you have a much different perspective and appreciation of what those jobs are and why people do what they do. And it's legitimate, and it's something that serves a very good purpose in our community and in our society on a broader level. So I think that the people who are on the CJCC council, who are law enforcement and defense attorneys and prosecutors, and we have one perception of what CJCC is about and how we can contribute to that purpose versus what inevitably becomes a public perception of the CJCC. And so my purpose today was primarily to say, simply because the court is participating in CJCC, I don't want that to be perceived as a loss of independence of the judiciary. And what I would say about dissent among the council members is just an observation, I guess, on my part. And it's normal with any organization, I suppose, that certain voices speak more regularly than others. And I think there's so many voices on this council that have so much to offer that I frequently leave meetings and think, I wonder what this person has to say about that or thought about that. And I didn't hear them speak up. And that's not a criticism. It's just a lament that, man, this council is such a good idea. There are so many voices that could speak that don't. And so to the extent that anybody doesn't want to go against the grain, or they perceive that to ask a question means you don't support an idea, that's how we get the best answers to questions or ideas, is to flesh those things out. So I'm speaking, and I feel like, once again, maybe I'm missing the mark on answering your question. So I don't know if that helps or not.
It does for me.
Okay. Well, I feel like I've taken up way more time than I expected with my comments, but if anybody else has questions or clarification, I'm glad to try and answer those things.
Hey, Judge, I just want to say I appreciate your comments, and both you and Judge Miller have reminded me of this from time to time, and I appreciate that. And I think the basis is if you're on this council, you need to be ready to be part of the discussion and share your ideas. That's your purpose for being on the council. And differing opinions will move us further along. On the flip side, this council is limited in the ability to take action, to state opinions, to drive policy. That is up to you as individual department heads or agency heads. Our job is to put that information together so that you have it when setting that policy. If we were to take action, then our judicial representatives would have to dismiss themselves from the council, which would really make us a three-legged stool. So, I appreciate that, Judge.
Yeah. And I just want to explain, I moved out of my office and was walking down the hall, not to add flair to my comments, but because that generator was so loud, I had to move over to the conference room. So, okay, thank you for allowing me to address that.
You're on mute, Pam.
Sorry, I thought pushing my space bar would do that. The next item on the agenda is Dr. Cravens and Mike Brower to give us an update on the serious mental health issue bookings into the county jail in 2019.
And I think for the sake of time, Pam, we'll
Okay.
table that. Most of the
You want-
information is there. I'll put some more on the meeting summary and we can talk about that in September.
All right, well, moving on, we'll talk with Captain Simmons at the jail about the update on the population at and usage at the county jail.
Thank you. I appreciate that. Just so you know, there's some maintenance going on around here too. So if you start to hear some drilling, I apologize up front. So just a couple things when we talk about the numbers here at the facility. As part of the subcommittee on the COVID jail subcommittee, we talked about this, presented to the county commission a week ago on some of these slides. I just want you to everyone to understand that, you know, as we continue to talk about this, there's going to be some information that changes, obviously, because that's how the population changes. So if you see information in the world, or you see something on the county commission, and it's different, that is okay. That's what's going to happen as we move forward through this pandemic. So, Mike, if you could move to the next slide on the functional capacity. There we go. All right. So just a couple of things. This was the actual slides that were presented to the Board of County Commission about a week ago. I'll go through these, and then I'll let you know the numbers that we had in the facility last night, and to kind of show you the fluctuation. So when we talk about functional capacity versus capacity, the jail holds 186. That is just 186 beds. What we talk about with classification system is the functional capacity, which is leaving a few beds open in each housing unit, which is about 10%. So as somebody moves from, say, medium to minimum, there's room available. Or if somebody needs to move from medium to max or special management or whatever that next classification is, then there's room there. So that functional capacity for the jail is about 167. With COVID, it's about 150. That was a projected number that we had discussed here with the command staff, and where we would be. We've had to make some changes in the facility to be able to accommodate the quarantine area, which is a 72-hour quarantine where each individual has their own cell, their own bathroom, separate from everyone else. So last week we had max special management and the medium pods were all full. Our medium pod today, we actually have 11 cells available as of this morning. Our women's housing unit, which was our it's a 14 cell, but we double bunk, so it held 28. We had to move those females over to our minimum male classification so that we could put our those newly arrested or those that are just coming back from a hospital or from a court or whatever out of facility event where they have their own bathroom. And we do not double bunk the males for security reasons. So that is now our pre-class or male observation unit. On the 27th, that was full. And then the next day, the 28th, those folks went from whatever classification that they were placed into or released. So then it went down to 3. As of today, we have 2 in that unit right now. So we're essentially have a 28-bed unit we can use for 14 males, but we only have 2. And that's how we have to quarantine. So that's where we are with that. And then our minimum male, we moved it to a women's housing unit. And so all the women, minimum or medium classification women are in that unit. And that's 28 bed. And we have 11 females currently today. So those cells are called dry cells, which means they don't have any water. There's no bathroom facilities in there. So it's kind of, they each have their own room, but it's like more of a dormitory style restroom. So that's what we're working on now. Our work release, it is also a minimum men's unit. A week ago, we had 29 out of 46 beds. This morning, we have 23 inmates in that housing unit. So we have 23 beds, basically beds available. That is an open day, open bunk style housing unit. Because of what we were going through last week with our medium housing unit completely full, we had to take 15 of our male medium and house them out of county. So you can see there, Jackson, Anderson, Jefferson, and Potawatomi County are all opened up in very small increments to take a few, which is a only services that are going right now. We don't have any programs, no volunteers, nothing coming into the facility because of COVID. Reentry, they're actually starting to see some of our individuals in custody before those that they would normally see are part of the out of county inmates. So there's 4 that aren't getting any services. We were essentially functionally full at about 126 for medium and maximum and special management inmates last week. Right now we're at 113, and 113 today, and we actually have cells available in each of those housing units. It just depends on who comes in. Obviously, we can't control who comes in, who law enforcement brings into us. So that's what we have going on. The facility itself, obviously, as most buildings and facilities aren't as designed for any kind of pandemic that we're in now. This facility wasn't built for that as well. We have 186 beds in our facility, and 70 of the beds they don't lock. 28 of those beds are behind a door but don't lock. They have the open bathroom, and then the 46 are just open bay, open bunk. So alternatives to incarceration. A lot of those individuals that we housed in the minimum and the work release area, they're on. So that's kind of how the jail is working right now. What we're struggling with is to find space for the quarantine for COVID because our medium max special management units are full. Let's see. Other things here. In addition, the Kansas Department of Corrections has informed the Kansas sheriffs that they will not be taking any transfers to prison until at least mid-September, which obviously is a problem for us and in all jails across the state because those that have been sentenced or here are on probation violations for the states, they're staying with us. So there's no way to move those folks out of our custody into the state's custody. Right now, they have 10 individuals they need to send to the facility to serve some time. That's on their waiting list. Law enforcement obviously is still not making arrests unless absolutely necessary that they have to come to the facility. So what that means for us and what we know that's going to happen is all those cases that were going through the process at COVID, essentially they've stopped, it's getting backed up, and then everything has essentially happened from COVID until now, where law enforcement has, instead of making that arrest, they've sent, they call it long form, or sent that information into the district attorney's office or the municipal courts in the county are waiting for charges. So we know it's coming, that there's going to be an influx of individuals in the facility at some point when all of these cases come due. So that's what we're dealing with right now. We're in fairly good shape this week. It's kind of going with whatever the courts or law enforcement bring us. So, anybody have any questions?
Yes. Does this mean that there are no women inmates that have been housed in other counties?
It depends. When we first started with COVID, what we did was we took all of the women in our facility, and we had, I think it was Jefferson County. I can't remember if it was Jefferson or Leavenworth. I'm sorry. And that sheriff's office housed those women for us. But right now, we had to bring all those back because we were getting an influx. So all the women that are housed in our male minimum unit now, that are minimum or medium custody, are here in facility, and then any of the maximum or special management women actually being housed in booking. Did I answer your question?
Yes, a booking in Douglas County.
That's correct. That's correct. Because the housing unit that the women are in right now, those are the non-locking cells. And so if you have a maximum or someone with some mental health issues or some behavioral issues, you have to have those folks behind a locked door. So they've been moved to booking.
Thank you.
Well,
Are there any other questions for Captain Simmons?
I guess I do have a question. Captain Simmons, you mentioned that you're expecting an influx. I know that, none of us can sort of predict what's coming with COVID and that, but what are the numbers that you're sort of expecting, at some point, there are X number of arrests that are not happening. What is that number?
right. And, so we can't necessarily we can't necessarily predict that.
I think you're muted.
Stacy, yeah, you're muted.
Okay, can you hear me?
Yeah.
But you'll have to repeat everything.
Okay. You can hear me? Yeah, that's fine. Okay, so, right, we can't predict, it's going to be 30 or 40 or 50. But what we can say is the alternatives to incarceration pre-COVID were already in place. So there wasn't anything that's necessarily changed from COVID until now. So there's no magic number that's going to take place. But what we can tell you is there are people who are not going to go to court. That's just the way it is. That's how it's been for years. So with all of the cases that the district attorney currently has waiting to be sent out, there'll be summons. Some of those people are just not going to come to court. That's just how it's going to be. And at some point, in order to get them to even go to court, there's going to have to be a warrant issued for that. And that's just me being a realist. We see it every day here. If there was some magic way that we could get those folks to go to court instead of getting a failure to appear warrant, we're on board with that. But so there's going to be people who are going to come to court, not going to go to court, and they're going to get warrants. There are also people who are going to have mandatory minimum sentences once they go through the court system. That's not anything that there could be an alternative to incarceration for unless you change the law, the Kansas law that says these are the mandatory minimums, and somehow the judges can just skip over those. So when those people get through the court system, if sentenced, they're going to be mandatory minimums. We are going to get those people.
I also think this is Sarah, it's important to note too, and that there's a number of cases that are in the district attorney's office that have not been formally charged because court is not in session. So it's not just folks that haven't been arrested yet. And I hope, I can't tell if Stacy's still trying to talk and I just talked over her or not, but that's an important consideration as well as to what is coming.
I might add a little bit to that also. I just looked this morning at the number of cases that we have kind of stacked up waiting to be filed for summons to be issued. And there's at least 55 of them that are sitting, waiting to be ready to go. Frankly, those cases date clear back to March and April, and we've got to start moving them. And I sent Judge Mccabria an email earlier today that I'm sure he probably hasn't had time to take a look at yet for his thoughts and input on, but I think we're getting to a point where we're going to have to start feeding these into the system a little bit because they're starting to get stale and old, and people need their cases resolved, whether you're the victim or the defendant, and we've got to start moving forward with these a little bit. We have enough process built into the system now that I think we can start processing some of these cases, getting pleas and resolutions worked out and getting hearings done that will not cause us to clog up court time. But as we start filing these cases, we are going to have situations where, summons will be issued. They will not appear on those summons. We can, be creative and try to issue a second summons or something like that if we wanted to. But eventually, if they don't appear for court, the court will typically issue a warrant on those cases.
I can probably add some information about failures to appear because we've been open, municipal court's been open for about a month and a half now, having our full dockets, and our failure to appear rates are up right now. People aren't coming to court, even with all the notification we're doing, which includes text and voice notification. People aren't coming to court at quite the rate that they were previously. So they're already probably out of municipal court 5,000 warrants in the system, not from the last couple of months, but in general for failures to appear over the last several years. And we're adding failure to appear warrants during this time. They're not all going to warrants immediately. We're using other notification processes, but if people still don't show up, there ends up being bench warrants. And I think that's what Captain Simmons is talking about. She's talking about the fact that at some point, law enforcement who's not serving or who are not serving those failure to appear warrants right now will eventually decide that they have to or get around to serve those failure to appear warrants. And when that happens, then there'll be increased court activity, and that will increase the stress on the jail. I think that's probably what I took out of it, at least.
Does that help, Darren? Because I guess I want to make sure, this is a really complex issue where things are coming in from different places. And so, one of the things that we really struggle with is how do we make it clear to people? And so I'd be interested in your thoughts.
Yeah, yes, it does help. I think that what Judge Miller just helped to do is give me some focus in terms of what, for lack of a better term, what offenses we're actually talking about, right? That in addition to what Captain Simmons is saying, because I think that's also part of what I, at least as a member of the public, am trying to parse out is like where the pressure is, and then thinking about, again, the role of the CJCC, what is being done about alleviating that pressure and what can be done. Like, for instance, I didn't know that text messages were going out, because I'm thinking like, okay, well, how are people being notified about their warrants? I hear Captain Simmons' point about, if there is another way of getting people to just come to the court. Wondering like, what have we explored some of that? But yes, to your question, Sarah, that does help me at least understand where the pressure points are right now, as opposed to sort of a narrative of, oh, there are, marauders from escapees from justice who are riding through town. That's not what we're actually talking about.
I'll just say to that, Darren, Dr. Cravens and Judge Simpson, Division 5, have been working for the last couple of months on a data set on FTAs in the jail over the last 3.5 years. And we plan to have Dr. Cravens present that in September and hope for some robust conversation about brainstorming on how to deal with failure to appears.
And it is I'm really looking forward to this yeah, I'm really looking forward to that conversation. I think there's a lot of layers in failure to appear, and it's also really hard to get at certain pieces data underneath it, and in terms of the base offense. And so it's going to take a lot of peeling back of the layers of the skin of the onion to really figure out all the different issues involved. And this is not going to be a one size solution fits all situations in terms of how to address it. So it's real. It doesn't sound exciting because it's got an acronym that's failure to appear, but there's lots of layers to it that have a lot of seriousness for delays and throughout the entire criminal justice system.
Well, I think the argument that you're making there, Sarah, that is compelling to me is that regardless of if it's, the sexy topic, it is the pressure point, right, in the system, and it's what is stressing the system. And I'm all on board of, back to Judge Mccabria's point, of us really leaning into a work session of saying, okay, once we've laid out what Captain Simmons is telling us, what Judge Miller is telling us about what the situation is, leaning in hard into saying, okay, what else can we brainstorm to make happen as we peel back those layers. So yeah, I think that, and to Judge McCabria's point, as people start to think about obviously this broader, now multi-year discussion of the jail, what do we need, what do we not need, that it does need to be clear in the minutes and what comes out of this, that we're actually talking about the things that are causing capacity stretches, and that we aren't talking about random murderers, or that that Douglas County is about to implode in lack of safety. That we're talking in a lot of cases about some procedural things and FTA and what does that mean. That's my 2 cents.
Something you might be interested in knowing is that sometimes even people who are arrested and placed into custody refuse to come to court by video. It doesn't happen on a majority of cases by any means, but it's something that happens regularly every month, even when someone's sitting in jail and all they have to do is come down stairs and go to the courtroom in the jail. Some of those people refuse to leave their cells and come participate in the judicial process.
I have so many questions about that I want to unpack, but I see that we're already at 12:30, so I'm going to just shut up. But I acknowledge that I hear that and I have questions later.
It's going to be a great discussion for September. We have one final thing that we need to resolve before we adjourn today. And Mayor Ananda, do you want to talk about the implicit bias training for the end of the month?
Yes, I'm happy to. Thank you. We do need to make a decision about this before we walk away from the meeting today. We had scheduled the implicit bias training for the 29th, and we had decided that that was going to be in person, and Loretta Summers, as well as this group, felt like it was pretty important to have that in person. So I wanted to check in with folks, see how we're feeling now. I know this month is kind of a tipping point month, I think a lot of us feel, or at least those of us who work in academia. The conference room at Public Works can be set up so that everyone has their own table and still distance at those tables. We will be ordering box lunches, but we would be wearing masks, or we can wear masks when we're not eating or drinking. And so I just kind of wanted to take the temperature of the room and see how folks were feeling about that on the 29th. And we do need a decision today.
I still feel like it's very important to meet in person if in fact we can meet those guidelines of social distancing and wearing masks.
I would also be in support of meeting in person with masks and social distancing practices in place.
I did wonder, and this wasn't part of the proposal, if there was an opportunity to be outside for this. Would that be an option that folks would be interested in? And I'm bringing this up without having brought it up to Mike beforehand. So if Mike, and I can't see if Mike's apoplectic right now, but I wanted to throw that out there as well.
I would support outdoors even before indoors if, you know, the conditions are conducive.
Agreed.
Yeah.
Cosign.
So I can reach out to Loretta Summers. I think she would be the one most affected by that decision, and see what she says.
So do we
So
have
is there,
consensus?
yeah, I'm wondering if anybody is opposed to that in-person aspect of that, or would like to move the date or continue conversation around this.
This is Michelle. I'm comfortable with the in-person meeting. I would prefer indoors just because of distractions and, you know, I don't know what you had in mind, Jennifer. Did you have a place in mind that was like covered or?
Nope.
Okay. All right. Yeah, I would just worry about, you know, possible distractions of wind and papers blowing and technology, but I'm definitely open to going ahead and meeting in person either way.
This is Mike Patrick, and I'm in favor of meeting in person as well.
Likewise.
I'm good with it as well.
Kim, I'm not hearing any no's, so I will swing it back over to you. Thank you.
Yes. I think now we are left to any comments, suggestions, or recommendations from anyone in attendance. Seeing none, the meeting is adjourned. Thank you, everyone.